question is, how do you conduct independent testing that simulates real-world attacks?
So we have...
Okay, maybe you can answer that, then I'll ask you the second question.
Not a problem, Matthew. So we acquired a company called Trustee back in 2016. So they are an information security specialist. So they've done stuff for Facebook. The guy that started is this former special agent of the FBI. So they've done this type of stuff for organizations for since 2000, which is 16 years. So obviously with that, we from the insurance side are able to see all the claims that happen. So we understand what the threat path that these actors take. And then on the back end of that, we actually have the digital forensics experts that go out and remediate those things. So when we do real life attack simulations, what we'll do is we'll figure out, we'll do something called a penetration test or red team test, and to sort of figure out, well, what's the path to gaining access into your information security or your information architecture. And then once we figure that out, we won't necessarily play it out practically so the organization gets to do it. But what we'll do is we'll sit down the executives in a room and say, well, for a couple of hours, whatever the case may be, and we'll say, okay, here's the scenario that's being played out, and this is how you build out a playbook, and you say this is what's happening conceptually, and then you start asking what are the responses, and initially you'll see a lot of mixed faces in the room saying, well, who's supposed to be taking care of what and what, and I think that's where you build that out, right? And once we do that, we come up with lessons learned. Organizations actually start to see, okay, this is what plausibly that's what the risk looks like for us. So hopefully that answers that question.
All right, no, thank you very much. And the second question is, how often do you measure feedback and results and lessons learned from testing and source code analysis into developer?
So it's dependent largely on industry. So if it's, for instance, a bank, it may be a little bit more frequent. A technology company, it'd probably be high frequency. Whereas if you're looking at a manufacturing plant, a little bit less frequent. So the time span may be different. And if you think about the regulation around, if you look at Basel. You look at some of the banking regulations, they require testing to happen a little bit more frequently. So that journey and that reiteration may happen more rapidly. So it all comes down to, to the business need, but you always try to go about that journey so that if something does happen, there's at least some kind of thought process associated, whether that be a question for the risk and audit committee to answer to the board. But fundamentally, it's to say that we have thought about this. This is what our thinking looked like, and if we weren't prepared, it wasn't because we weren't being negligent. We were being negligent. So hopefully that answers that question.
Thank you. Okay. Do we have another question? Another question to Zamani? Alex, do we have online questions? Okay, Zamani, what do you think would be the key threats that pension funds should be worried about? Where do you think are the points where pension funds could be attacked?
So, I mean, for you guys, for the pension fund space, you have sort of two gold mines. Firstly, you deal with large amounts of money, and then second, you deal with very sensitive data. So if it's one, not some type of malware. So malware is basically a computer virus that changes the output of a specific process. So practically what that means is that if I press X on my keyboard, the X won't actually pop up as X, it'll pop up as P as an example. So if you think about that from transferring of funds or administrating of funds, think about it in the same way. So you may think a process is taking place that you've done for a couple of years, but actually there's an underlying process that's taking place, which is either, again, redirecting funds or duplicating records in order for them to be able to sell those records off and create fraudulent activities in any case. And ultimately, the last one of that, I think the biggest from a cost perspective to a pension fund is the data. So if they lose data or they have client data that's in a highly regulated area, there's going to be, again, subsequent losses that come with either consequential damages, liability, and things of that nature. So I think those are the two things, and a lot of work. I mean, I've had clients that, and sort of small pension funds that have had a payment redirected because a client's email had been hacked, and the pension fund acted on that client being truthful when actually it wasn't the case. So the funds were redirected somewhere else, and when the client came back from vacation, they were like, where's all this money? I never gave you this instruction. So it's around that thinking and making sure that there's various controls in place to stop that happening. And I think generally, just from a business perspective, one of the biggest things I've seen as, I guess, a risk to the finance industry, or not necessarily a risk, but something that needs to be cognizant of is blockchain. I think that's huge. It's got huge potential to sort of really disrupt that market. So those would be, just off the top of my head, three things I would take into consideration.
Okay, and according to your analysis, I know you've got offices in a couple of countries in Africa. Do you think pension funds are ready? Are they, like, their systems? Are they in place to mitigate these threats?
It's a tough one. I would say to some degree, yes. But I think the proactive space we need to be a little bit more ready for. I think we look at, because obviously every country has regulation as to how information security should be managed in an organization, especially one is regulated as a pension fund, right? So as long as they're meeting those obligations, for them, in their eyes, they think that they're fine. But I think there needs to be a lot more work around understanding what's the value proposition behind getting an accreditation to an ISO 27001 standard or a NIST standard, as an example, and just being a little bit more proactive from a response perspective. So I think the threats, they somewhat understand it, but I don't think they understand what happens once a breach actually occurs, because it's very disruptive. Very, very disruptive. So I don't think that they're ready from that standpoint. And I think part of the problem with regulation not allowing companies to, or not requiring them to announce if they've been hacked, is that the business environment starts thinking that it's actually not a real risk. So what we're going to start seeing is a lot more companies saying, actually, hey, this has happened to us. And we had all of the systems in place, but we just need to be a little bit more coherent in terms of protecting our data and our processes. So, hopefully that answers that, Steve.
Okay, thank you very much. Unless we have another question, I will let Zamani take the rest of the day off. Thank you very much, Zamani. Hope to see you soon. Thank you for the presentation, and I hope my delegates appreciated that. And if they need to contact you, your details are on the screen. They will be in touch very soon. See you soon.
Much appreciated. Take care, guys.
Okay, bye. Okay, so with that, we will shoot direct to our day's agenda. Our speaker facilitator is here. We will have a half-day workshop on governance, employee benefits, and investment management. Our speaker Henry. Henry, you say Dul, or I think this is Afrikaans, eh? Dutch. Dul, yeah. He's the managing director of Independent Trustees Services and quite experienced in the space. Henry is a former judge and has been conducting training across Southern Africa for many years, and he's the one who's going to take us through. So I think from your profile, you saw what he's going to be looking at: fiduciary duties, legislation, trustee responsibilities, to members, to the fund, to stakeholders. He's got experience with the King 4 system. I think most of like the East African, maybe they might not be familiar with the King 4, but South Africans are very familiar with this. So, Henry, I don't know whether you require this kind of mic or.
I think, can everybody hear me at the back? Okay, thanks. I just want to link up the computer. So after the exciting 2 days of talking investments and all the exciting stuff, unfortunately, you have to listen to me today. The less exciting governance issues. Okay, thanks. So yeah, I'll try to keep it exciting, but I know I've got a hard task ahead of me. Just with regard to Mr. Facilitator, do we have until what time do we have to finish this meeting? Is it the normal time?
Yeah. Earlier. Yeah.
12:50. Okay. Okay. Thanks. Can you see my screen? I just want to start it. Good. So it's a trustee training workshop, basically looking at the fiduciary duties of trustees. And just a little bit about myself. I've got a law degree, studied through the University of UNISA. I've got two postgraduate diplomas in life and pensions funds. I've got investment analysis and portfolio management and investment foundations qualifications. And I'm a chartered principal executive officer through the Federated Institute. I've got more than 30 years experience in the industry. I was a public prosecutor and then a magistrate. A number of management positions, a number of membership positions, consulted to a number of large clients. Got some personal past chairman of the London Community Policing Forum, Institute of Parent Teachers Association, award committee member of public safety, and I'm also the author of a practical guide for the pension fund trustees, which is AIM Books 2015. So what I'm going to talk to about today, the agenda, basically fiduciary duties of trustees, the trustees' responsibilities, and then King 4 and treating customers fairly. Now, King 4 and treating customers fairly is very well known in South Africa, probably lesser than the rest of Africa, but very valuable indeed. And I think everybody will benefit from looking and listening to these matters raised there. Let's first talk, first of all, I'm just going to try to see if I can get a remote control on. So give me a minute. I really do like an interactive approach. So if there's anything you want to ask me while I'm busy, please interrupt. Let's discuss. This is first of all your session, not mine. I'm just here to assist. I was actually thinking about it. I've been in Kenya. I've been here before, and sitting at breakfast today. The staff is so very attentive, very, very attentive. Can I bring you coffee? Can I bring you tea? So very serving. And I thought to myself, you know, this is life. We serve each other. So what do we do as boards of trustees? We serve our members. It's not us that's important and having to look after our funds and look at all the money we control and look how important we are. We do it for our members. We serve our members. I'm here today to serve you. So I want to part with you the knowledge I have, and hopefully it will assist you in serving your members. But I'm your servant for the day. So please interrupt if I do something or say something that's not clear. Please ask me. I will explain. The duty of me today is to make it clear to enable you to understand. Just got to connect this. Right, so what is a fiduciary duty? I mean, we hear the word on a regular basis. Now, I often try to explain it. Basically, it's very, very easy to understand. If you look at it, if your neighbor comes to you and says to you, please look after my child. I've got to go do some shopping. Please look after my child. How do you look after the child versus how you look after your own child? Differently. Because your own child, you know what they're doing. You know what he's up to or she's up to. You know, when they're quiet, you know, they struggle, they're doing something. If you don't see them, you know what they're up to. If it's your neighbor's child, you don't. So you have an extra care when your neighbor's child is there with you. So you look extrally after your child, after the neighbor's child when you are there. So the word fiducia comes from the Latin term fiducia, which means trust. And if you look at a legal dictionary, legal.com, it says a person who has the power and obligation to act for another. To act for another in the circumstances that requires total trust, good faith, and honesty. There's a couple of very, very important aspects in that. You act for another, you've got power, you've got an obligation. It requires your trust, it requires your good faith, it requires your honesty. It's a duty that someone has when he or she deals with other people's money or property. So please remember, the fund is a separate legal entity. So the fund acts separately. It can sue, it can be sued. It's not a trustees, it is the fund. You as trustee or the board of trustees just manage the fund, similar to a board of a company managing the company. So the board of trustees is responsible for the management of the fund, and the principal executive officer reports to the board. So the principal executive officer is sort of the chief executive officer of the company, of the fund, and he reports to the board of trustees. In the end, the board is responsible. Please.
I just want to get clarity on ways that the board of trustees is responsible for the management of the fund. So if they sue the fund, they sue us.
They sue the fund, first of all. They don't sue you. They sue the fund. But you can be held personally liable. And we will talk about that. I will go into detail. You can be held personally liable, but they sue the fund first of all. So you will find in many cases, there's actually a case I think that I referred to later, which is the Amplats Provident Fund and certain trustees that were sued. So the fund was first of all sued, and then the trustees were added as second, third, fourth, etc. respondent, certain trustees of that fund. In terms of the Oxford Advanced English Dictionary, what is a trustee? A trustee is a person in charge of the property of a trust or of the business affairs of an institution. What is a director? A director is a person who manages the affairs of a business company. So what's the difference? It's just the entity that's different. So it's just like being a director of a company. As a trustee, you're a director of the fund. You've got similar responsibilities than directors have. However, your responsibilities actually is a bit more strenuous than a director's responsibility. Of course, you work with other people's monies. So you're required that you trust in good faith, or that you act in good faith and with honesty and sincerity of intention. You always act in the best interest of the fund. And this includes avoiding any conflicts of interest. And you cannot exceed the powers that's granted you in terms of the rules of the fund, in terms of documents and legislation that apply to the fund. So you are restricted to act within those requirements. I'll try to get this. So the following fiduciary duties are imposed on a trustee. As I said, you do not exceed your powers. So you cannot act outside of your powers. You have to exercise your powers for a proper purpose. You've got to maintain an unfettered discretion. So many circumstances, many cases, you will have a discretion. You've got to exercise an unfettered discretion. You must avoid a conflict of interest. In all cases, you must avoid a conflict of interest between your interest and the fund's interest and the member's interest. You've got a duty to act in the best interest of all stakeholders. Now, who are the stakeholders of the fund? It's not just the members. It's also the employer. It's also the authorities, the governments. They also have a stake in the fund. And it's also your service providers. They also have a stake in the fund. So you've got to act in the best interest of all the stakeholders of the fund. Very important decision in South African law. Now, trust law comes from British law. And big parts of Africa is subject to British common law as well. Kenya, inter alia, I know, is also subject to the British common law. And this Robinson Randfontein Estates Gold Mining Company is a decision in 1921. So next year it will be 100 years old. It's an appellate court division decision, so it's the highest court at that stage in South Africa. What an appellate court says you do, it says where one man stands to another in a position of confidence, involving a duty to protect the interest of that other, he is not allowed to make a secret profit at the other's expense or place himself in a position where his interests conflict with his duty. Okay, this still applies. This is 100 years later, this still applies. If courts rule on these matters, they still refer to the Randfontein case, Randfontein Estates case, or the Robinson case. This still applies. It hasn't changed much. In actual fact, in the recent Supreme Court decision in South Africa, that's what a judge actually said. He said, this law has not changed much. Now it's stuck. Okay, very important that the board of trustees act as one. So you act jointly. And that's why you're jointly and severally liable. What does that mean if you're jointly and severally liable? Back to the question the lady asked in front. As the board, first of all, you sue the fund. As a board, you are together responsible, but the independent but the claimant can also claim against you as an independent, as one trustee. So what do? They would go and look and say, who's the rich ones in this board of trustees? And we'll sue them. Why sue the poor ones if they can't afford to pay our claim in any case? So they can decide to just sue one trustee, one individual trustee. That trustee then will have to go to the other trustees and say, well, I've been found liable, you were all liable, so you've got a case against all the other trustees. But whoever sues, you can decide who he wants to sue. You are covered. Most of funds in South Africa, I'm sure, I think it will apply everywhere. We have to take out professional indemnity and fidelity guarantee insurance. So if we are negligent, we are covered. But if we are at default or willful default, we are not necessarily covered. So if we act in bad faith, we will not be covered. Another important case that you might find interesting, fellows, was Pillstone. This is a 2004 case. So this is nearly 20 years after the case I referred to earlier, the Robinson case. And this court also referred to the Robinson case. Now, what happened in this case? Person A was employed by Company B. And while working for Company B, he did some work for Company C on behalf of Company B. While doing the work, Company C offered him some shares in his personal capacity. He told the board of directors, or he told the directors of Company A that it's been offered. They said, no, you can't take it, it's our shares. He still took it in his personal capacity. Company A sued person B. No, sorry. Company B and A and C gets me confused. So Company B sues person A, and the court ruled in favor of Company B, and that person A was not allowed to have taken these shares, and he actually got a secret profit from taking these shares. In this case, if I remember my figures correctly, he bought the shares for 300,000. He sold it for 1.2 million. He had to pay the 900,000 rand profit to Company B. Because he made a secret profit, it was their profit. Very importantly, what a judge said in the Phillips case is there's 3 characteristics that's imposed on an obligation where there's, or when there's a fiduciary obligation, where there's a trust situation. There must be a scope for exercise of some discretion of power. If you don't have some discretion of power, you're not in a position of a trust, you're not in a fiduciary position. The power of discretion can be used unilaterally to affect the beneficiary's legal or practical interest. And there's a peculiar vulnerability on the part of such beneficiary to the exercise of that discretion. That's typical what happens in a board of trustees, isn't it? So as a board of trustees, you've got discretion. You've got to exercise your discretion. You can use it unilaterally. That can affect the beneficiary's legal and practical interest. And the beneficiary is particularly vulnerable to the decision you've made. If you decide you're going to provide the benefit, the withdrawal benefit or the return benefit to somebody else, there's huge vulnerability for the beneficiary. In the Tech Corp Provident Fund, it's a well-known fund, a well-known ruling in South Africa. The court made it clear that the trustees must also always follow the rules of the fund. You cannot act outside of the rules of the fund. It's also embedded in Section 30 of the South African Pension Funds Act. You've got to follow the rules of the fund. So you cannot act outside of the rules of the fund. If the rules of the fund says the beneficiary is X, the beneficiary is X. You cannot decide the beneficiary is Y. Just a question on that. If your rules say something, and the law says something else, the act says something else. Let's say the rules say, at death, the beneficiary will be the spouse of the deceased. And the law says, this is the law of South Africa 37C of the Pensions Fund Act says, as a board of trustees, you must investigate and distribute the matter or the benefit in terms of Section 37C, and that will include all dependents, will include a spouse, legal dependents and factual dependents. What do you have to follow? Which one do you have to follow? That's then against your rules, isn't it? You have to take the law. Absolutely, you have to follow the law. But if it's a spouse's pension, then the rule makes provision for a spouse's pension. You cannot go and say, well, it's now determined in terms of Section 37C, and I should pay it out in terms of Section 37C and consider all the other dependents. Your benefit is a spouse's pension. It's not a death benefit. So you've got to be very careful when you look at the two and where they're in conflict with each other. Are they really in conflict with each other, or is it just your interpretation of it? So be very careful in how you read your rules and how you read the act. Let's look a little bit at African legislation. So what do we have in South Africa? We've got a Pensions Fund Act. And then we've got a Financial Institutions Property or Funds Act. And that deals with the investment side, custody and administration of funds and trust property by financial institutions. Okay, can I just ask the delegates here, who's from Kenya? Can you show me by hand who's from Kenya? Who's from outside of Kenya? Just two people from Kenya. Who's from outside of Kenya? Okay, where are you from, Anna? Zambia. Okay. Also Zambia. Also Zambia. Okay. Also, okay. Anybody not from Kenya and Zambia? Yeah. Okay. Zambia was also, I've trained there before. I think the act is not much different than the South African act. There's a couple of nice things I've also seen, I think, in the Kenyan act. I think you're actually quite ahead of South Africa. Is it Kenya? You've got to submit your financial statements within 3 months. South Africa, we're still fighting. We've been told we're going to be compelled to submit our financial statements within 3 months. We're still doing it within 6 months. I think it's now going to be 4 months when our new act comes into. Zambia must also 3 months, is it? Or is it longer? When do you have to submit your financial statements in Zambia? 3 months also. Okay. So, you know, we South Africans think, oh, we're so ahead. No, don't we? We're so blasé. We are the leaders, we think. We're not the leaders. There's lots of legislation all over Africa which is substantially better than our legislation. And this is just, to me, one example. When I get to South Africa and people fight with me, say, well, why must they reduce it from 6 months to 3 months? I say, well, we can all do it. You should be able to do it within 2-3 weeks. If your financial systems work properly, you should be able to produce financial statements within a couple of weeks. Why wait 6 months to produce your financial statement? It's just, to me, shows that our administration systems are not what they're supposed to be, what we should be. Okay, so bear with me if I refer to South African legislation. I don't think South African legislation is necessarily better than legislation elsewhere. I think there's a lot that we can learn from legislation all over Africa. So if I refer to something that we do in South Africa, you think you do it better, please tell me. I would like to know that as well. Right, some other legislation that's applicable in South Africa. The Constitution, of course, and it was a very good case. I think I referred to it. The NS Malindi case about the DNA tests for children in South Africa determine if they are dependents of the deceased, where the deputy adjudicator Matume Tulare actually went and he referred to the constitution, say how children are protected in the constitution, and the board of trustees in this specific case did not consider the constitution duly. So the constitution also a very important aspect in our fund regulation. Labour Relations Act, Employment Equity Act, Promotion of Equity and Unfair Discrimination Act, the Wars and Maintenance Act, Financial Advisory Intermediaries Act, Income Tax Act, Promotion of Administrative Justice Act, Long-Term Insurance Act, Access to Information Act, Protection of Personal Information Act, the Financial Sector Regulation Act, and now the Coffee Bill is coming out, the Coffee Act is coming out soon, which will replace a number of these acts and change everything. And you still want to be trustees? You've got to follow all this legislation. You've got to be aware of all this legislation. Not easy to be a trustee these days. And then the fund rules. The fund rules is the fund's constitution. It's the fund's legislation. And it's unique to each fund. And it will provide details about membership, about contributions, about benefits, and about management of the fund. So any questions you have about what you should do in special circumstances, you go to the fund rules and you find what you should do in terms of the fund rules. And then, as I mentioned, Section 13 of the Pensions Fund Act South Africa says specifically, and followed in the Tech Corporation case, you've got to follow the rules of the fund. You cannot act outside of the rules of the fund. There's regulatory bodies. I'm not done yet. Sorry, there's still other things you've got to look after. Okay, not just the acts and not just the rules. It's also decisions made by the regulatory body. The regulatory body will issue what used to be in South Africa. They issued the PF regulations. They issued directives, and you had to follow those. In some circumstances, you had to follow those. In some circumstances, they were not binding. That has since been replaced with different regulations that they can issue. And their job, the financial sector conduct authority's job, is to ensure that an efficient financial sector where customers are informed and trusted exists in South Africa. Then there's the pensions fund adjudicator. So the pension fund adjudicator, or adjudications made by the pensions fund adjudications, rulings made by the pension fund adjudicators must not only be followed by the specific fund that it is made against, it must be followed by other funds as well. Okay, so what does the pension fund adjudicator do? It investigates fund-related complaints submitted to it within 3 years. So you've got 3 years to submit your complaints to the adjudicator. The adjudicator must deal in it in a fair, economical, and expeditious manner. It makes provision for conciliation process. And as I mentioned, the rulings of the adjudicator must be followed by the fund and each other fund where it's applicable as well. Yes. So the question is if the adjudicator is bound to timelines in making his ruling. I just for interest sake, just read about a judge in South Africa. It took 4 years to make a decision in KwaZulu-Natal. And yes, that's clearly not what you want. You want a decision as soon as possible. There's nothing prescribed in the law on what a timelines is. I've found you could expect the adjudicator to come back within a year. sometimes 18 months, sometimes earlier. It depends very much on the workload of the adjudicator. There is no specific timelines, but something that maybe they should consider putting in the law, putting in the act. Maybe the adjudicator should make a decision within 6 months or something, because it's often required. Because who goes to the adjudicator? It's the poorest of the poor. Somebody that needs assistance from a higher authority, for lack of a better word. And how can you wait too long? Exactly. Absolutely. So, very good, very interesting point. Yeah. Another question.
Just to follow up on the 7 points of timelines, who will push you against that? In your opinion, what do you think would be reasonable time?
Yeah, what would be a reasonable time? That's a difficult one to say. I think it depends on situation to situation. And from when do you time it? Because you get a complaint. What happens when you get a complaint? When the adjudicator gets a complaint, adjudicator will then send the complaint to all the affected parties, ask them to respond. Then normally what you do is let's say I feel my disability or my withdrawal benefit that I received was not sufficient. I would then go to the adjudicator, complain to the adjudicator. The adjudicator would write to the fund and the employer and ask them to respond. The employer often don't respond because it's got nothing to do with them. They feel it's got nothing to do with them. It's a matter between you and the fund. How long do you give them to respond? They don't even come back and say, I've got no interest to respond. They just don't respond. So how long do you have to wait for them to come back to you? Maybe the response you initially get from the fund is not sufficient. You need to do some more investigation. So you ask them for more information and they could have come back again and respond to you. So there's nothing difficult to say. It depends from case to case. But let's say, I've got some funds, just to give you an idea, I'm looking after that's historically been, or I've been appointed by the authority to look after these funds because there's no trustees, or maybe there's been problems with previous administrators, so there's data problems and things like that. I've just placed one of those funds. I've moved from one administrator to the other administrator, and I had a meeting with them in the past week, just about a data that was transferred from the previous administrator to a new administrator. I said, well, listen, guys, if we get an adjudicated complaint, this is the kind of data we need. You can't just open the data with fund values. They just got a fund values of the members as at a certain date, and they want to carry on then. I said, well, what will happen if a member comes to us and say, I have not been paid this and this date? You won't have the data. So if you're a fund and you haven't got a data, you've got to go and find the data. It could take some time to really find the data. So difficult, a real lawyer's answer, isn't it? Don't commit to anything.
Thank you. My name is Stella. So what happens when a member is not satisfied or even the scheme with the decision of the adjudicator? What is their second point of recourse?
Thanks. Also a very good question. You used to be able to take the review to the Supreme Court, so you could approach any court, but that could be quite expensive. So there's now a review process with the Financial Services Conduct Authority. There's a retired judge and a couple of legal experts that sit there. And any decision that they are unhappy with will go to them, and they can review it and send it. They cannot substitute the decision. They can send it back to the adjudicator to reconsider. So that process is now available as well.
Thank you.
Is there similar processes in Kenya and Zambia? If a member is unhappy, how would a member deal with a case like that in Zambia or Kenya?
In Kenya, if a member is unhappy, first of all, you don't have the adjudicator. So when a member is unhappy, the issue is referred to the Chief Executive Officer of the Retirement Benefits Authority. If they are dissatisfied with the decision of the chief executive officer, the matter is then referred to the tribunal of the Retirement Benefits Authority. If they're dissatisfied with the tribunal of the Retirement Benefits Authority, then the matter is referred to the High Court of Kenya.
Yeah. It's a similar kind of process. Huh? Okay. Just been shown there's a question online which I missed. Thank you. So the question is, kindly clarify the order of priority amongst the regulations, trust rules and deeds in common law in exercising their fiduciary responsibility. Thanks, Evans. Also a very good question. So which one do you follow? Okay, first of all, any act is the first one you will follow. So if an act says something, you will follow the act. Of course, if there's a Supreme Court determination on how to interpret the act, then you've got to interpret the act in terms of the Supreme Court decision. Regulations are sub-rules from acts. So you will then, secondly, you will follow the regulations. Thirdly, you will follow the rules of the fund. Okay. Common law's got similar strength than the act. So common law and the act will sort of have a similar level. If a certain matter is enacted, the common law principle will fall away. If there's no legislation dealing with a certain matter, then a common law principle will be followed. And I was just thinking about the example I wanted to say, and that example's gone out of my head now. Okay. Good. For some reason this thing doesn't want to work. Okay. Didn't understand it, but hopefully when we get there, you'll help me again. Okay. Yes, this is where we were. So we spoke about a pension fund adjudicator, and just a very good example on what a pension fund adjudicator has done is the Tole case. Sitole versus ICS Provident Fund, and another 2004 case, which is a pension fund adjudicator case. And it states the factors that you've got to consider when the distribution of the death benefits are the following. You've got to think of the age of the dependent, relationship of the deceased, extent of the dependency, wishes of the deceased, financial affairs of the dependents, future earning capacity of the dependents, and the amount available for distribution. So there's nowhere in the act that anything says that this is the things you have to consider. But the adjudicator said these are the things you have to consider. So that's what we follow in South Africa. Clearly, there's something else that comes up that you think, wow, this will add value. You can add it as well in your decision. Only if it can add value, if it can enhance the process. This was also followed in the Malindi case, which I referred to with the deputy adjudicator, Advocate Tulare. We also did the DNA testing. Very interesting case for those of you that's interested in something like that. And I just thought now on the previous question, the matter that was raised, which one is precedence, the act, regulations, etc. There was a recent case in South Africa. So what a law in South Africa says, if you in terms of the Pension Funds Act, the minister could make certain regulations. So the minister made a regulation, which was quite a number of years ago, probably 10, 15 years ago, Regulation 35.4, which he then issued. And basically, it came to being that you cannot use the unclaimed benefits in the fund to enhance other people's unclaimed benefits. And it created a whole new thing in South Africa. We've got unclaimed benefits funds, etc., etc. What we've done before that regulation came out was if there's no situation, for instance, let's say there's an unclaimed benefit in the fund, and if we look at the calculations, we cannot trace the person, we cannot trace any dependents. The person would have been 120 years old by now. The chance of the person claiming is very limited. Yeah. So what then? Sorry, just got to get my train of thought back there. So what we did with that money, if there's no chance of the unclaimed benefit being claimed, we would then use that money to enhance the benefit of the existing members. And then the regulation 354 was issued by the minister, which says you cannot use that for that purpose, which means we accumulated all the unclaimed benefits. And I think in South Africa at the moment, the unclaimed, some couple of billions of rands, the value of the unclaimed benefits at the moment in South Africa, which is going nowhere. I mean, they're unclaimed, they've been traced, the funds done everything to trace the members, they cannot trace the members. But now it goes into an unclaimed benefits fund. So who's going to benefit from this in the end? This matter was taken to the Supreme Court by a number of funds, and the ruling came out, I think, early in November this year, which basically said the minister acted outside of his powers. He didn't have the powers to make this regulation. That regulation was then scrapped. And that's a typical example of what would have happened. The minister made the regulation in terms of their act. The Supreme Court then came and said, well, I say you can't have this regulation, so that thing falls away. The regulation will effectively fall away. Okay, that's just an example of how would you follow the different situations. If your fund rules say, because if this matter is not addressed specifically in the act or anywhere else, and your fund rules say something about it, if your fund rules, for instance, say unclaimed benefit will be kept in the fund in perpetuity, you have to keep it in the fund in perpetuity for always. You'll have to keep it there because that's what your fund rules will then say.
And I think just to comment on that, I think that's what makes practical sense to keep the unclaimed benefits in the fund.
Yeah.
Better the money growing than just remaining stagnant. Hopefully the person won't.
Yeah, well, but if you look at it and there's no chance that a person will turn up, for instance, the person was born in 1890. So that person would now be how old? 150 years old. Chances of that person claiming is probably zero. You've done everything to try to trace this person and the dependents, possibly people that could inherit from this person. You can't trace, you advertised, you did everything. Nobody comes forward. What do we do with the money?
So that means it becomes part of the fund and other people.
You can then, yeah, it becomes then part of the returns of the fund and other people can benefit on it. Yeah.
For how long would you trace it before financing appears?
It will depend on each circumstance. And the Board of Trustees will have to make the decision on what they think is reasonable and what they think they should do.
So in Kenya, we have the Unclaimed Financial Assets Act, which requires that any unclaimed assets are remitted to that body within 2 years of those assets. Like now for pension schemes, when a member attains retirement age, either at the normal retirement age is 60 years, within 2 years, their funds should be paid to them, or if not claimed, if the trustees have made all the search and they've not been able to trace this person, within 2 years, those funds should be remitted to the Unclaimed Financial Assets Act. But it's interesting to hear what South Africa, the challenge that was posed to the Supreme Court about what the funds then, what then the Unclaimed Financial Assets Act does with the funds. Yeah.
Yes, well, we tended to, after Regulation 55.4 was issued, we tended to follow a similar approach. It says after 2 years, unclaimed benefit will then go into an unclaimed benefit fund. And this was a case going for long, very, very long. And now there's legislation, the Coffee Act that will come out will probably change it again. So the Coffee Act will probably go back, and then it's an act, the regulation, the minister was not acting outside of its powers, then we will have to follow the act. But the question is, if it goes there, where does it go from there? What's going to happen from there? Why must other people benefit? Who's going to benefit from it? I mean, if it goes in South Africa, it goes in an unclaimed benefits fund. At the moment, it lies in the unclaimed benefits fund. It lies in the administrative charge and administration fee. And often the money is so small that after a while the money is nil. And there's no benefit left. And the money then really accumulated to the administrator. Surely there's some benefits as well. It's large. That will it accumulate? To who will it accumulate to in the end? Now, I'm busy with a fund that was closed down in 1979. Now that's 50 years. That's 60 years ago. 79? No, that's 40 years. No, my son is 50 years ago. So 50 years ago, there's a couple of million rand in the fund. I've been looking to try to find these people. I cannot find these people. What do I do with the money? I'm going to put it in an unclaimed benefits fund in the end. Who's going to benefit from it? In the end, the government will benefit from it. You know, in South Africa, we're not very, very excited if government benefits from it at the moment, you know, because it tends to go to individuals and not to the people of South Africa. So if everybody contributed to the fund, why should it not go back to the fund? Why should everybody not share in it from the fund? Because we share in the cost, we share in everything. Why can we not share in this? But if the law comes out and the law says that, you've got to follow the law. So in Zambia's case, that's what the law says. You have to follow the law. You've got to do it that way. Kenya, sorry. Okay, so the Pension Fund Act deals with governance, it deals with financial operation of the fund, and it deals with benefits and allowable deductions. It refers to regulatory instruments, and these days it's a rule or a conduct, conduct standard or directive, which was issued by the authority. And that's in terms of Financial Sector Regulation Act 9 of 2017. Right, this is the boring part. So I'm going to run through it very quickly and then, or should we break before I run through it? Let's quickly, I'll go quickly through it. I'm not going to spend much time on it. I might look at a couple of things. Just what an act consists of in South Africa. Chapter 1 is the administration, application of the act. And interpretation starts with definitions, application of the act, talks about the register and deputy register of the Pensions Fund Act. So that's section 3 of the act. There's quite a couple of good definitions in the act. For instance, dependent in relation to a member means a person irrespective of the member is legally liable for maintenance. A person irrespective of whom the member is not legally liable for maintenance if such person was, in the opinion of the board, upon a death of the member, in fact, dependent on a member for maintenance, is the spouse of the member, is the child of the member, including a posthumous child, an adopted child, the child born out of wedlock, and see a person irrespective deals with the legislation and incorporation, deals with the legislation of pension funds, pension funds which the state contribute to financially. Very interestingly, in that Pension Fund Act applies to all private funds. It does not necessarily apply to all government-controlled funds in South Africa. So they want to control the private funds, they don't want the same control over their own funds.
4B deals with the effective administration of the pension fund. Transfer to pension fund referred to section 4A of its assets held by another. 5 deals with the effectivization of a private pension fund. 6 deals with allocation of assets and liabilities between pension fund organizations and other associated businesses. And then there's a number of sections. I'm not going to go through all of them. Or chapter 4 deals with the various documents that need to be submitted to the registrar. 16 carries on a number of issues. I'm not going to go into detail of each of them. Required by a registrar, so that in South Africa, the registrar can actually intervene in the management of funds. So the registrar, for instance, is of the opinion that a board of trustees do not properly manage the fund. You can remove that board and appoint its own board. Often happens that funds just stop. So this fund, as I said, was a 1979 fund, so they paid everybody except 3 members. And then there was no board of trustee anymore, and the money just lied there, so nothing happened to it. So if the regulated African appointed what we call a Section 26 board, the responsibility will then be to take the position of the board and get specific duties to perform. In this case, what we try to do is to praise these members, pay the dividends of the fund. You can't pay or you can't praise these members, you will move the money to an unclaimed fund. Chapter 5A deals with the adjudicator. Chapter 6 is just general information that we're going to give to the adjudicator or to the regulator. Certain penalties, there's high penalties for if you do not submit your documentation within a certain time at the start, you can be fined up to 4,000 rand the day that you were late. So there's some huge fines that you can incur if you don't do what you're supposed to do for the fund. If you think about it, if the fund incurs these penalties and the trustees was negligent, can the members sue the trustees to pay the fund back? I would say they probably can. But there's a risk for the board of trustees there. And you probably will not be covered by a professional indemnity if I do the guarantee policy because you were grossly negligent in not submitting your information on time. And then the last section deals exemption from the Act, litigation assignment with restrictivity. So there's one chapter. Okay, it deals with regulations. Yeah. Then is regulations, capital part 1, 2, 3, 4, 5, 6. 7 of the regulations. And there's a number of regulations. I'm not going to go into detail on it. Why we say regulation 28, this is very important to how you can invest. Overseas, for instance, we're limited to invest 50% of our assets. Overseas, 5% in Africa, we can invest 5%, which doesn't fall within the limits of overseas investments, so additional investments that you can make into Africa. And then how you can invest now. those of you that's old enough would remember the Enron scandal. I'll refer to the Enron scandal a little bit later as well, but the Enron scandal was a electricity company in the US which went bankrupt, and all their funds, money was invested in Enron itself. So their members not only lost their jobs, but they also lost all their pension funds. The regulation to prohibits you to invest more than a certain percentage of your money in one company. Some interesting new regulations was introduced the last couple of years with the default investment portfolio, default in-fund preservation, and default annuity strategies that was introduced as well. Now, the investment portfolio, just interesting default investment portfolio, most of us already had that in the funds, and also that used. And the default preservation, in-fund preservation, certainly something new, and the annuity strategy certainly something new as well. I don't think it's been very successful, so it will be taken up by members, but it is very strict members required. And then you get board notices, you get fund directives, you get information circulars, you get PF circulars, all those you have to follow. They've been in place by the Financial Sector Regulation Act. Prudential standards, provide service providers specifically, that will be administrators, will be life insurance companies, banks, etc. Contact standards requires mostly to retirement funds and how you could conduct yourself. And then joint standards, which will apply to both service providers and retirement funds. A standard is an instrument identified as a regulatory instrument in the financial sector. So we break. If we come to break, I think it's just over half past. So what time? So it's 15 minutes. So we're back at about 10 to. Thank you. The definition in a dictionary, the Oxford English Dictionary of a trustee is it's an individual person or member of a board that's given control or powers of administration of property in trust with a legal obligation to administer it solely for the purposes specified. The Board of Trustees should act fairly in the best interest of the members, responsibly, never take sides, always do what is best for the fund. In terms of the Pension Fund Act, the Act actually states there should be a minimum of 4 trustees. 2 of them, or 50% of them, a minimum of 50% should be member elected. And the rest could be appointed by the employer. And you'll get the details of how this should be done. You'll find it in the rules of each of the funds. So as I mentioned, African legislation says 50% should be elected by the members. It doesn't mean that you cannot have elected by the members. You can have more than 50% elected by the members. The fund rules will have how many trustees there should be, how often they should meet, what the election procedure is, how long they should be in office. A beneficiary fund is a fund where it's minded beneficiaries. Their benefits are paid into the fund. Clearly, the beneficiaries, 4, 5, 6 years old, cannot elect members to the board. So you can apply for exemption from Section 4A of the Act in terms of Section 4B of the Pension Fund Act. What normally exemption would be granted, they would want at least one independent trustee, but preferably 50% of the members of the Board of Trustees should be independent. Section 7A also talks about the levels of the skills that's required on the Board of Trustees. It's been introduced a couple of years ago. Now it's only been effective from this year. By the end of this year, I think actually the 12th of January or 16th of January next year, all trustees must have completed the trustee toolkit, which is on the regulator's website, for them to be trustees. All new trustees got 6 months to do the trustee toolkit and qualify to prove that they've got a necessary skills. There's certain whistleblowing requirements. So within 21 days of them becoming aware of a trustee becoming aware of any material matter, which in the opinion of the trustees may seriously prejudice the financial viability of the fund or its members, they must report it to the regulator. There is certain responsibilities on the board of trustees and member to do that. And this is an individual member. It is not a board of reporters, it's an individual member. This liability lies on the individual member. We spoke about earlier, there's a question about who you could sue and who you can't sue. This is a typical example. The Unclaimed Group Provident Fund and others versus implicated board members. They just sued a number of board members. Not all the board members, just a number of board members they sued. The fund actually sued these board members. And they sued Vivian Cohen, who was actually to the fund. And thirdly, they sued Sanlam Life Insurance Limited, who was the administrator. It was for a 40.5 million loss due to incorrect unit price calculation. The trustees and the administrator was cleared in the end, so they actually was held liable in the fund. So it actually is liable for the 40 million rand. It's gone on the review since then. So, yes.
So in that case, why was the actually held liable on the trustee
So what is happening in this case? We actually had to, on a regular basis, calculate the unit prices for the fund and send it to the fund. And we made an error. We did it in the spreadsheet, and we actually just hard-coded one of the cells in the spreadsheet. And that had an effect right through to the end. The IT people will tell you exactly what we did. That's good.
So he was liable because he didn't.
He was negligent.
He was
yeah. So adjudicator found that for a person in his standing and his capacity had to show more care. Didn't show sufficient care, and it was less held liable. Okay. Trustees were not held liable. But there's numerous other cases where the trustees were held liable. The first case was an art medical case where the trustees did not pay the group life assurance over to the insurance company. There was a death claim. Death claim did not pay out from the insurance company. The adjudicator found the trustees should be liable in personal capacity for that. There was the firm marketing case where what the trustees did in this case, the member record was in shambles. The member record was totally bad. And it had to rebuild. They then appointed one of the most expensive service providers to rebuild it for 40.5 million rand. Was a quote that they received. They appointed these people, and 40.5 million rand was attached for member shares of the fund to pay for this. This matter was taken to the adjudicator. The adjudicator ruled and held the trustees personally liable. I think it was 6 trustees, no 4 trustees. I'm not sure. They were held liable in personal capacity. They have taken it to the High Court, and it was overturned since then. I personally thought it was a good determination. I just thought the adjudicator erred in how she got to the determination. I think the result was good, but the reasoning to get to the determination, as far as I was concerned, was flawed. And that's why she lost it on the review as well. So yes, trustees can be liable. So when are you not liable? I think they introduced Section 7F a couple of years ago. where the board can relieve a trustee of liability. So now we go, we sue all the trustees, and you did this, you didn't do this, you're liable, I lost so much, you're liable. Now the court can say, well, if the trustee acted independently, if he acted honestly, and he acted reasonably, he could be held not liable. Not in all cases has to, it could be held not liable. Or if the court thinks it's fair in the circumstances, you could hold him not liable. But only if there was no willful misconduct or breach of trust. If there was willful misconduct and breach of trust, the trustee will always be liable. So it's important, I often tell my trustees, if you disagree with the way the board is going, make sure your disagreement is noted. You cannot go against the board, it's majority rule. If the board decides they want to go to specific investment, you feel uncomfortable, make sure that your discomfort is noticed in the minutes. If anything happens, you can say, I was against it, I fought it as hard as I could, but I couldn't, I was overruled. You don't want to go and fight outside of the board. It is Africa for intersite in a ticket, governing board just recently. Now, this week, a board member was removed because he wouldn't follow the rest of the board. And that's right. You can't fight the board all the time. It's a majority rule. Majority makes a decision, you abide by the decision of the majority. You cannot continuously fight about a decision they've made. But if you're uncomfortable with it, make sure that it's noted, it's in the minutes. If anything happens, you can go back and say, but I was independent, I was honest, and I was reasonable. I should not be held liable in this case. It's very important. We've gone far in Africa, I must say, we've gone far in a minute. If we keep some people, some funds still don't keep minutes as good as they used to, or as good as they should. In the past 10, 15 years ago, we just minuted decisions. Nothing else, no discussion around it, just the decisions was minuted. Now, certainly the boards that I sit on, we minute all the discussions. Don't need to minute everything word for word what everybody says, all the important points must be minuted. The stance is taken by the board, by the members of the trustees. It must be minuted, put out. And if you're uncomfortable, please, for your own best, make sure it's noted in the minutes that you're not happy with that. Section 7C and 7D, PF Circulars 96. PF Circulars was issued by the FSCA, the FSB, when they issued PF 96. This is a guideline. PF Circulars was never law that to be followed, but it was guidelines. But they say, or they give you guidelines on how you should act as a trustee. 7C of the board of the Pension Fund Act says the object of the board is to direct, control, and oversee the fund operation. And that's important. You directors, you've got to control it, you've got to oversee it. You don't have to do it yourself. That's why you outsource it to a dedicated administrator. But you are still in control. You still have to oversee. You still got to give direction on what has happened. Don't let the fund administrator overrule you. Don't let the fund administrator bully you into something that you don't want to do. It's your fund, you must do it, and you're responsible in it. Pursuing the object, the board shall protect members' interest, specifically in the transfer and amalgamations of funds, splitting of the fund, termination or reduction of employer contribution, increase of member contribution, withdrawal if an employer terminates. So this African law makes 5 specific incidents where trustees must play a specific interest in. Doesn't mean the others is not important. Others are also important. But these 5 are highlighted by the legislature. So please look at these things. They are very, very important. In pursuing its object, the board shall act with due care, diligence, and good faith. let's say you've got a number of participating employers in the fund. Let's say you've got an employer that's consists of 2 or 3 divisions, and he sells on one of the divisions, and he now moves out. I'm involved in one specifically, the platinum at the moment. There used to be, I think, 4 funds on it. They're all moving out and starting their own funds, and etc. etc. So that would be typical splitting of the funds. There's a lot of interaction or similarities between amalgamations and transfers and splitting of funds. Okay, so act with due care, diligence, and good faith. Some people say at most good faith. But it's only bad faith and good faith. It's not good faith or better faith or best faith, whatever. It's only good faith or bad faith. You act in good faith, you avoid conflicts of interest. This is often a thing we neglect. We think if we can just manage our conflicts of interest, we're fine. That's not sufficient. It's not sufficient to just manage the conflicts of interest. You must manage it, you must avoid it. If you can avoid it, you avoid it. If the odd circumstance is you cannot avoid it, then you've got to manage the conflict. You've got to act independent and impartial. You've got to find UC. Used to say you've got to find UC duty to the fund, and I've added restrictions that UC duty to members and beneficiaries in respect of accrued benefits. They've added that a couple of years ago. I've got my own interpretation of what that actually means, accrued benefits. And if I use the duty to members and beneficiaries with accrued benefits, let's say, argument's sake, you pay a member, and a month later, there's extra money coming into the fund for whatever reason. And the members, we haven't paid in the full benefit, so there's 10 Rand left in the fund. That's an accrued benefit. Now, what we've done in the past, he said, well, it's just not cost effective to distribute it to the member. It costs more to pay it into his bank account. So, of course, we thought if I use it to the fund, we save the fund money and we distribute this 10 Rand between the other members. But now you've got to find use it duty in terms of accrued benefits. So, what are you supposed to do now? Okay, very difficult question. And you've got to comply with the SCAT requirements. That's, for instance, submitting your annual financial statements on time, submitting your actual evaluation on time, submitting all your documents, your rules in time, all those things. If it's prescribed, you must do it. You've got to keep it. So actually says it wrong. Some of the duties of the board, you must keep registers, books, records. You must make sure proper control systems are in place. You must communicate information to members. You must ensure contributions are paid on time. Now, just to give you an idea of keeping registered books and records and proper control systems in place, I've got a number of funds that was sort of called in old funds. For years, nothing happened on these funds. We found there was money on the fund. We appointed by the regulator to look after these funds and close these funds. These funds are managed on a spreadsheet. And I'm very concerned about it. If it's on a spreadsheet, you don't keep proper registers. You don't keep proper books. Is the control systems proper in this case? And I raised my concerns. I wrote to the regulator, I said, well, I am concerned that there's not proper control systems in place in these cases. You must go look as a board of trustees. It's your duty to go look at the administrative system. Go see if the system actually works. You have a look at the system. It's important that you do that. You've got to obtain expert advice. I've done a discussion with the one gentleman outside now about investments. We're not investment experts. Well, where do we invest? We don't know. Most of us are not investment experts. So we get expert advice. We get an expert to come and assist us in making investment decisions. Ensure the fund complies with legislation and comply with all the SCAT requirements. Fund fund using duties is not specifically mentioned in the Act. PF 130, the guideline was issued in good governance. It recommends that you have certain policies in place. For instance, a code of conduct. Once you have a code of conduct, how should the trustees conduct themselves? What does the trustees do? And when you first came on as a trustee, what did you know? What are you supposed to do? You don't know anything. What am I supposed to do now? So, have a code of conduct. Give you some indication of what you're supposed to do, how you're supposed to do that. Gift policy. What kind of gifts can I receive or not receive? I remember many years ago, I actually trained a board of trustees from a church. We spoke about gifts, receiving gifts, and one person said to me, but it's our tradition. It's been our tradition for years. Somebody comes to the village, they will bring a goat to the chief of the village. Right? Yes, it's true. What's the intention of being the goat? The intention of being the goat is to win the goodwill of the chief. Why? Because I want something from the chief. If somebody brings you a gift, why do they bring you a gift? They want your goodwill. Because they want something from you there. So be very careful when you accept gifts. And have it in a gift policy. Because look, I think you all got pens in this conference. Is that an issue? No. But if your gift policy says it's an issue, not you decide what is the issue or what is not the issue. And the benefit and pricing policy, not specifically mentioned in PF 150, but certainly something I think you should have in your policy. What do you do with unclaimed benefits? You price these people, how often do you price, what efforts are you supposed to make in finding these people? A risk management policy. You should have a risk management policy. Identify the risks of the fund and how are you going to manage those risks? Communication policy. How will you communicate to your members? Investment policy statement. It's required in terms of Regulation 28 and in terms of PF 150. You have an investment policy statement. It helps you make a decision. It helps you if somebody comes and shows you a nice scheme. We've recently had, I don't know if you're aware of it, a pastor from Malawi who fled the country because he was arrested for some fraudulent activities. Bought a nice hotel in Rustenburg, etc., etc., etc. Okay. And these guys can be, wow, they're good speakers, huh? And good convincers. And they are brilliant with these kind of things. And you get it. And your asset managers, like, I always laugh, your asset managers come with dark suits. They've always got dark suits. Right? Nice. Always good guys. Okay? Not like us. You come with those jeans and chinos, they're always, I think they're born in those kind of things. They're smooth because they can sell well. They always send their best sellers as well. Right? They can sell well. If you've got an investment policy statement, it says how you will invest, what you will consider. It keeps you from making those kind of decisions that will bring you to the ground. So investment policy statement is very, very important. I hope you don't have any asset managers in the audience or online. I do apologize if you do. So what is governance? Yes. Very good. Another policy you can have, the scheme remuneration policy. Should we pay trustees? What do you think? Who says we should pay trustees? Hands up. 1, 2, 3, 4, 5, 6. Oh. Okay. If we not pay trustees, I guess other people would say we shouldn't pay trustees. And I think it's a debate. I'm a professional trustee, independent trustee, so clearly I get paid to sit in the board of trustees. All of the other people don't get paid to sit in the board of trustees. I think we should pay it. It's an important task. If we pay somebody for something, they take it more serious. I've seen so many board of trustees that people don't come and prepare for the meeting. Right? It's just, oh, the trustee meeting tomorrow. Where's my document? Let's go. Quickly. They don't care. But if you get paid, it's not that. Look at it quite different. So I do think you should be paid. But yeah, it's an application is not a tendency to pay more. But you should have that. And even if you don't pay your board of trustees, what about expenses? Traveling expenses. You should have a travel expenses policy as well. Where do we stay? In a best hotel, 5-6 stars hotel, or do we stay in 3 stars hotel? Do we fly business class? Do we fly economy class? All those things should be in as well. I'm very aware of time. The concept of governance is not new. What is governance? Governance is just the management of the fund. It's nothing else. You know, we've couple of years now we talked about good corporate governance. Wow, this is such a big thing. We must have good corporate governance. It's management, it's nothing new. It is really nothing new. Okay? It's just guidelines to help us in what we can do. What are the instruments we can use to make sure we've got good corporate governance? But it's nothing new. 10 years ago, 20 years ago, trustees didn't have no governance. Of course they had governance. Of course they had good governance. But all these are here to help us have better governance. Good governance will ensure corruption is minimized. Oh, I should say this to our government. The views of minorities are taken into account. The voices of the most vulnerable are heard in decision making. It's also responsive to the present and future needs of members and stakeholders. You should have a strategic vision, but if you have a strategic vision, you must work towards a vision. I've seen so many funds that say we want the replacement value for our members of 70% or 80% of their salary when they retire. It's in the rules, and that's the only place you ever see. It never gets discussed, it never gets worked, it never gets analyzed. Are we actually in the route to get us 60 or 70%? Why are we not? I've got one fund that we've done it recently. So, what is our replacement, net replacement ratio for our members? And it was under 40%. We've got 80% target in that fund. So what are we doing about it? Because we think that most people actually have outside revision. So let's investigate if they do have outside revision. It's our duty as a board. I don't want something out of the strategic vision for the fund. It's no use. The same with these governance policies. It's no use if you have these governance policies and you don't use them. You must use them. It must be there. It's a tool to assist you. It is not a tool to keep the authorities happy. Keep them happy too. But the main aim is it's a tool to assist you. I'm going to speak a little bit. Governance is about seeing that the fund is run properly, with decision and oversight structure. Mitigate risk of total investment failure. That's why you have a risk management policy. With a risk management policy, it provides good governance. You can identify the possible risks that you can have on this fund. Just to come back to the miners review, it was done in the UK in 2001. As we said earlier, a culture of pension fund governance was developed in which trustees would treat their responsibilities very much like the job of running a company. Of course, that's exactly what it is. You're like the board of directors. You're called trustees, but you're like the board of directors. Some funds are actually bigger than the company who contributes to it. It's your responsibility as the board of trustees to look after this. Okay, one thing is the number of principles. I'm not going to run through the principles due to lack of time. You would see it here at 150, it's relatively old, 2007, it was introduced in 2007. There's been a lot of talk of reviewing it and then making it a sort of a directive, a conduct standard that we will all have to keep to it. I think it's high time. In a way, I'm against over-regulating. I think worldwide, we in a phase of over-regulating. We want to tell everybody what they need to do, wear your mask, how to take your mask off, how to wash your hands, etc., etc. It's good. I think it's all good. But I also think there's things that we as people should do ourselves. We should know and do ourselves. We don't need to be regulated. I remember a number of years ago when King 4 came out, King 3 came out. I sat in a seminar somewhere, and one of the questions was, why don't we put in the duty of the principal officer in the act? I'm totally against it, because if we codify everything, what about those things we haven't codified? Who's going to do that? And if you say everything, you need to do this, and you forget something, who's going to do that? I was like, that's not my job. It's not in my rules. So I stay away from it. So I'm a little bit against that. These things are supposed to be guidelines to assist you in guiding in what you should do. These are the different policies we spoke of. I'm not going to go into detail on them. Important policy as well is the education policy. What do our trustees need? How do we establish what a board of trustees need? How should our board of trustees, who should it consist of? In Africa, we have member elections, which in principle is brilliant. I think it's brilliant. But who do the members tend to elect? The pretty people, the good looking people, yeah, or the people with the biggest voices, yeah? Not necessarily skilled people. So what should we do as a board? Then we should say, well, we lack the following skills. Maybe we need an investment expert. The fund is big enough, it's uncomfortable the way we invest in, get an investment expert. That's where independent trustees come in. And you can say, well, we lack somebody with accounting background. So let's get an accountant on the board. If you appoint somebody with accounting background, let's get an independent trustee for that. So look at what your skills is your board and what you lack. And train people, educate people. I mean, education policy in place to educate people. Yes, sir.
Matthew Chavara. I just want to comment on the evaluation of the board performance, which is critically important part of the corporate governance arrangement. Now, who is supposed to conduct the board evaluation? And what are some of the significant factors for each of that we should actually evaluate? Again, when it comes to the compliance issue, you can like the policy that you just talked about. I think the big issue is some of these compliance are being treated as box ticking exercise. So I just want you to maybe to give your proposition pertaining to how we should demonstrate in terms of compliance and corporate governance as a priority than treat as a box ticking exercise. Thank you.
Absolutely. Thank you for the question. I said it earlier as well. Often we do it because we want to keep the regulator happy. So we have all these documents in place and we file it somewhere. The regulator come for a visit, and they're all fine, you just give me my guide somewhere in the cabinet. It takes you 10 minutes, maybe you dust off and say, there you are. What is the use of that? Nothing. There's no use. It's a document to assist you in doing what you're supposed to do. It must be a living document. You've got to ask the question, how am I keeping to this document? How is this document helping me? It doesn't help me, it's no use. Find a way that it will help you on this card in totality. Evaluation, that to me is also very, very important. What do we do? We as a board evaluate each other. No, we don't want to avoid my husband. I don't want to give you a bad mark. You're going to give me a bad mark next time if I give you a bad mark this time. So we try to be nice to everybody. We give a 2.05, we give everybody 4. You know, I'm one of those people I never give a 2 marks. Some people get 2 marks, some people get 4. Never go and give less than that. So I think we should have some harder facts that we can determine. You attend all the board meetings. I've got it in my agenda. Facts now of all my funds, attendance in board meetings. The person was here or wasn't here. Do you attend board meetings? Do people actually prepare for board meetings? How long does it take us as a board to make a decision? Do you take 3-4 meetings to make a decision? A board of trustees is long, it takes long, which is meet every 3 months. If somebody proposes something in the first meeting, okay, let's think about it. Next meeting, we discuss it. No, this is maybe a good idea, but we need some more input. And then, wait, another. So often here we make a decision. How effective is that? Sometimes you have to, I've got no problem, sometimes you have to do it, but often we don't do it. Often as a board of trustees, we don't want to rock the boat. We look for the easy decisions out. I've seen it so many times. Who do we appoint as the administrator? The big guys. Who do we appoint as the asset manager? The big guys. Because if anything goes wrong, you can say, well, everybody else is the same boat as we. We didn't make the mistake, everybody else made the mistake. But those are the kind of things you can look at and say, how good are we as a board of trustees? Do we follow the herd? Do we act independently? So find some hard facts. Go and do analysis. We make our decisions, we implement our decisions within 3 months, within 6 months, within 9 months, within 12 months. We are all at the board meetings. We are prepared at the board meetings when we can. Those kind of things. But it is difficult. I think it's one of the things we neglect and we get away with purely because we want to be nice. I'm going to skip this. This is to me very important. Well, maybe it's actually pretty much good. Goes hand in hand. So, Mr. Smith is a member of the trustees of the ABC Pension Fund. An applicant to tender is Mr. Smith's brother-in-law company. Mr. Smith is shocked, feeling rather uncomfortable. We remember discussing it with his brother-in-law over dinner at the weekend, but he didn't really think he would be there. What should Mr. Smith do? Keep quiet? And his brother-in-law is a different surname than he has. So Smith is everybody. Openly declare his conflict of interest and allow the chairperson to decide what to do about it. Openly declare his conflict of interest and excuse himself from meeting for this matter until this matter is being concluded. See? Anybody want B? Anybody want A? You can take it to the Heinz dilemma. Okay. So, I'll just talk about the facts more or less. We'll do exactly on here. I'm going to talk about the facts more or less. So this guy, Heinz, stays in a village and his wife is deadly sick. The local pharmacist managed to find a cure for the sickness and he's selling it for $1,000. Heinz can only, by hook and by crook, when everything is done, he can only get $500 from it. And the pharmacist says, no, I'm sorry, hard work went in here, I can only charge $1,000, I cannot refuse. What should I do? He can go in at night, burgle, steal the vaccine, the cure, leave the $500, but then the guy would know it was him, and then take the $500, or let his wife die. What of those 3 options should we do? Very difficult. And I don't have an answer. I don't have an right for a wrong answer. And this is the moral question about some decisions we have to take. There's not always a right and a wrong answer. And you will appreciate somebody might have a different answer than what you have. So morally, it's not that easy to make make a decision. We're pretty sure people struggling with making this kind of decision as well. The board and the principal officer has a fiduciary duty to ensure that they avoid the conflict of interest. Now, depending on what Africa says, the board of trustees have a fiduciary duty. It never said the principal officer has a fiduciary duty. Only now the Coffee Act coming into effect, there's a fiduciary duty on the principal officer.
Hello. I wanted to just announce that the team from Zamani is leaving now. So in case you want to say a word with any of them, they are transporting you. And then if you are leaving before going to lunch, we'll arrange, you can get a lunch pack at the main reception. Just make it like a park. Otherwise, they are leaving now. So,
They know the Coffee Act saying the principal officer has a fiduciary duty. As far as I'm concerned, the principal officer always had a fiduciary duty. So does the service providers have a fiduciary duty? Remember what they said, what is the fiduciary duty? When you work with other people's money on their behalf. And if you're the principal officer, you do that. If you're the service provider, you do that. So we all who's involved in the fund has got a fiduciary duty. Conflict should be removed or avoided. Let's move on. What is the trustee's responsibilities towards members, to the fund, to other stakeholders, and to each other? The fund's business is first of all to claim, to pay claims. That's what we're supposed to do. We pay people benefits. Disability benefits, death benefits, retirement benefits, etc. You must make sure that we manage the fund properly in terms of Section 7 of the Act. The members must receive proper communication. We must reduce the risk by proper governance structures. We must make counselling services available to members, somewhere they can go and ask questions and get advice from. We must make investment reservation and purchase of annuities something. Ensure that complaints are dealt with efficiently. In Africa, I've mentioned the pension fund adjudicator, that we've got, that you can go to the pension fund adjudicator if you've got a complaint. What the Act actually says, you've got 50 that you've got to go to the fund first. The pension fund adjudicator at some stage the rule, it's not necessary they will deal with all complaints. Recently they've changed their style and they said you must first go to the fund so the fund can deal with the complaint, and that's right. And my stance always, if there's a complaint, is it's the member's money. If he's complaining, find a solution. It is not a complaint against me as a person or anything personal. There's an error that somewhere happens. I need to find the error and resolve the error. It's the member's money. We mentioned these trustees' duties, so I'm not going to go through them again. Trustees' duties to stakeholders. What did we say are the stakeholders? It's the members, it's the employers, it's the authorities, it is our service providers. You must communicate effectively in a transparent, easy way. You must avoid conflicts of interest. You must act in good faith. You must identify and manage potential risks. At all times, act within a legislative framework. You've got a duty towards each other. You must prepare for meetings. You must participate in meetings. And please remember, people are different. Some people are quiet, so it doesn't mean he's not paying attention. But some people make one contribution to the meeting, while another person will talk all the time in a meeting. It's fine. People are different. We've got to accept that. But people must participate. Voice your opinion on the issue. Identify and manage risks. Act at all times within a legislative framework. act to the best interest of members, speak up about potential matters of contention, ensure that all members of the board are appropriately educated, ensure that there is a succession plan in place to minimize handover of the fund benefits. There's a number of duties. You must keep registers, books, records, control systems, communicate, ensure contributions are paid on time, obtain expert advice, ensure the fund complies with legislation. There's a couple of time frames for submission. I'm not going to go through them, but we've got to keep to these time frames and submit our stuff in time. But payment of contributions, there's a whole process in Africa on when you have to pay contributions. It must be within 7 days of when they are due. There's often a thing in Africa that we don't follow to the letter as well, which I think the trustees will be held liable at some stage if they don't. Member communication, there's a certain minimum communication that needs to be given to members. You must have a strategy, the fund must plan, have a budget. Many funds don't have a budget in the year. Have a budget. Any business have a budget. So as a fund, have a budget. Investment portfolio strategy should be appropriate, should be reasonably priced. Look at the pricing. Communicate to the members. Minimize the risks. Take social economic considerations in place. Offer good value for money. Not going to go through the portfolio strategies. But important aspects. If you select a manager of the strategy that aligns with the fund's objectives. Ensure that all the investment-related costs are reasonable. Ensure that the strategy is aligned to Regulation 28 principles or whatever legislation is applicable. Besides, ESG principles. Make sure it's in line with your investment policy statement. Regularly monitor the portfolio and provide members with regular, simple, and effective communication. Identify the risks on the fund and manage those risks. Are there any questions at this stage? Okay. We're running out of time. It's 10 to 12. I think there's somebody else that still needs to do a presentation, 20-minute presentation. So I'm going to skip, if it's fine with you, I'm going to skip back over team 4 and treating the customer fairly. Is it fine? Is it fine with the delegates? If I don't get a no, I will accept it's fine. It's corporate governance. These are examples of corporate governance failures. I mentioned Enron, Lehman Brothers, Merrill Lynch, AIG. We look at the losses. $115 billion US in AIG. Lehman Brothers, 51 billion losses. In Africa, Steinhoff, Prudential, African Bank. There's recent new ones. Company I cannot pronounce, I'm going to pronounce it. There's a bank, a vendor bank. All governance failures that's happened recently. Team 4 shows a number of principles that you can look at. It should be things that should be part of your core as well. It's often in legislation. But look at these principles, see if you adhere to these principles, see if they apply for you. A lot of them are in the Act as well, Section 7A of the Act of Team 4. Many of the principles overlap. Code for responsible investing. Treating customers fairly, that's something that's going to be part of the coffee bill in South Africa as well, but treating customers fairly was an initiative issued by the regulators in Africa. And it's basic principles, it's basic things that we should do in any case. We should not be given these things to do. What I said previously about over-regulation, these are my concerns for over-regulation. Unfortunately, because not all of us do these kind of things, we get regulated to do them. Any questions from the audience at this stage? It's nearly 12 o'clock. Thank you. A lot of us have to leave. Transport issues. Those of you that are able to stay, thank you very much. I don't know if there's any questions from the people online. That's fine. I think Stephen wants to ask one presentation more. And then that will be it. Thank you everybody. Thanks for the opportunity. Yeah, it's my pleasure once again to be here. It's still morning, almost getting to the afternoon, so I'll be making some lights to say good morning once again. For those who may not have met earlier, my name is George Uliga, and I'm the general manager at Unclaimed Financial Services Limited, a company with operations in Kenya, Uganda, and Mauritius. Registered in our core business is in pension administration, consultancy within the retirement benefit space, and training. Now, today I'm here to share something that's very, very interesting, which is a function of our research arm of the business. And this is something that we do between ourselves, Strathmore Institute of Mathematical Sciences, and the Institute of Human Resource Management, all based in Kenya. And we call it the ML conversation, which is a transformational, thought-provoking, and enlightening conversations within the retirement benefits space. So today, there are certain studies that we have done, and the journey has been long all the way from 2018, where we've done close to 4 research activities and been able to disseminate those findings into the retirement benefits industry with the hope that this is accommodated in the discussions around policy development and the like. So we started with governance of pension schemes in Kenya, and here we look at the case of trustee remuneration. It aligns to the question that the presenter Henry mentioned about whether trustees should be remunerated or not, and I'm glad that there was consensus on that piece. Then there is also retirement confidence, which we did second, and here we were looking at how well Kenyans are prepared for retirement, speaking into the replacement ratios that people are currently holding based on the saving levels that they have, and then we moved on to do retirement well-being, and this was also focused on the environment within our context here in Kenya, and then we looked at attitudes to inheritance, and this also gives some very, very interesting findings. What I'm about to share with you is around conflict resolution. And here we are looking at the conflict management and resolution within the retirement benefit funds. And this is a study that we rolled out around the 4th of September this year, which means some of the things that I'm about to talk about are actually very, very fresh still in our minds, and that they are within the context of the environment that we are in, which is where COVID has taken us. So in our study, one of the observations we had was that conflicts in retirement benefit schemes indeed do exist at different stages of operation.
So there was conflict at the time when they appointed trustees, conflict at the time when they appointed service providers, conflict at the time of onboarding a member, and conflict at the time of distributing a member's benefits. So with all this, then therefore, our interest was anchored on also the need to have all schemes comply to good governance guidelines and the conflict resolution policy being among the key documents that schemes need to consider having on board. So when we did this, we had a certain broad objective. The broad objective here was to seek to establish the extent to which conflicts were in existence in schemes, and also the consequences of the same conflicts and the approaches to conflict resolution within the retirement benefit scheme. So the specific objectives for this exercise included to determine the nature of conflicts encountered in retirement benefit schemes, to assess the extent to which stakeholders in retirement benefit schemes management understand the process of conflict management, and also to evaluate the consequences of conflicts in retirement benefit fund management, and the role of trustees in conflict resolution, and also highlighted the role of retirement benefit authority in conflict resolution. Our approach was to just administer questionnaires among different stakeholders in the pension sector. And here we did around 200 questionnaires, the sample size of around 176, drawn from the different stakeholders in the industry. And with a focus on Nairobi also, where most of these are actually centered on the same. And the findings were very, very, very interesting. It is what I'm about to share with you. One of the things or the pointers was that the gender that mostly suffers conflict was actually the female gender, and we got a good participatory rate compared to the male. Female participated at 53%, and the male participated at 47%. Respondents were drawn from the industry, and 19% came from the financial services sector. Public service also participated at a similar rate of around 19%. Hotel, tours, and food services at 11%, and then also at 11%. And among stakeholders, trustees played a very key role in this, doing 50% in terms of participation, followed by fund administrators at 9.3%, custodians at 2.6%, fund managers at 1.3%. When we sought to establish the scope or the period when this, whatever we were recording, would actually have been captured, around 49% say they had between 1 and 5 cases in the last 1 year, and then 13% say they had more than 5 cases in the last 1 year, and there were 38% who say they had 0 cases. And drilling down on this, maybe some people, we've gone through a lot such that certain things have actually almost become accepted as normal. You know, like if you're in an environment where you need to package something small, like to be able to get certain services, people actually look at it like it's normal. It is part of their budgeting process, and they have to approach that. And to them, maybe based on that experience, they are the kind that without actually even record things like, for me, I think no cases, you know, because ideally, the experience and the way things have been done over time is to them almost normal, and they have accepted the same. So the 0 cases number of 38%, we took it yes because it is feedback, but with a pinch of salt, of course. Because so anyway, data does not lie, so it is okay. They say no conflicts, so we left it there, which is okay. And then looking at the nature of conflict encountered, we were able to categorize them into around 10 clusters, and this included processing of final benefits, looking at conflicts around trustee expenses, trustee election and appointment, scheme investment, delayed benefits transfers, as well as selection of service providers, then reporting and accounting, then membership into the scheme, sponsor interference in scheme matters, delayed funding by the sponsor as some of the category based on the responses that we are getting. And what we saw here was that a lot of conflicts revolved around the processing of final benefits at around 50% as per the responses that we got during this study. So top causes of conflicts were pay, information, and then non-remittance of deductions, and then delayed payments. And on information, one of the key things it also very informed the issue we should have around member engagements and member education was that the people who are nominated as beneficiaries in most schemes are usually not informed by the members who nominated them. And the key reason here is that some of them have some mistrust and also the lack of preparedness at the time of payments. So that came out very, very strongly, and it should inform the way we address the issues of member education, especially towards what role the nomination of beneficiary form play in the schemes, and also beyond the pension space into other assets that people may be holding elsewhere. Non-remittance of pension deductions, I think they have been a bit significant based on the period that this study was held. This is because it was conducted during the COVID period. And within this period, we've had certain challenges with the same, where people have either lost jobs or we've had some employers also struggling with the remittance of pensions just due to the problems that we gave members within the pension schemes. And then on delayed payments, usually because of incomplete documentation, because that also includes some struggles, and also where there are conflicts that have not been resolved among beneficiaries, then there is a delayed payment where delayed payment being made in respect of a member who has passed on. So looking at the category of members with most conflicts, again, those who came out very, very strong to say that for them, they may appear like the category that suffers most were those who are terminated by employers. And of course, in a period where we've experienced a lot of redundancies being declared among different and across different sectors in the economy, and so this of course reflects some of the feelings that were on the ground. And then the category of terminated employees by employers was also followed by retirees, and then beneficiaries, and then those who are just voluntarily resign at 9%. And they are a very, very small minority at 4% of those who are immigrating. So on the amounts involved in these conflict conversations, again, we also sought to establish, is it inclined towards those who have more money in the funds, or is it inclined towards those who have less money in the fund, or where the benefits are relatively small? And what we saw was that the majority of cases lie around those who are receiving a payment that was less than $1 million shillings at around 40%. And then, so the skew here left us with another question. Is it because maybe those people who have larger savings are not too meticulous in terms of tracking their savings, due to the fact that by the time they are in that particular category, they are also diversifying their income enough. So they are not on really following on the nitty-gritties of how these benefits are and the like. And I think this also speaks to even the participation in AGMs, for example. You find that those who have even more money in the fund are the ones who either trust the structures and the like, and they don't feel like it is,
something to attend, for example. If you look at even the category of people who attend AGMs, pension schemes, you rarely see a lot of support from the senior category of members within a particular organization. You look at it like that is for the junior people to follow up. You know, for them, they are a bit more confident. So that is also part of the things that came out of this study, which was also interesting and should actually also inform our levels of engagement. Then we asked a question around who do you think has the ultimate responsibility in managing conflict within the schemes? And there's a unanimous response around pointing fingers towards trustees. That's close to around 50%, and then 50.5% say return on benefits authority. Others say it's the HR manager at around 10%. Maybe speaking into the HR as a custodian of records in terms of beneficiaries and the like for the employees. And then others pointed to the fact that it's the member who is responsible at 9%, an arbitrator at 5%, and the sponsor at 3.5%. But what this says is that for trustees, then therefore, there's a lot of interest in them sitting in a position of influence simply because they have a legal responsibility as owners of the fund to be able to then guide this, and the expectations as per these statistics are still very, very huge and speaking into their role. Of course, as legal owners, they remain responsible, yes. And in the exercise of their powers, there are those that they do directly, there are those that we have discretionary powers that cannot be delegated, and then there are those others that we are able to delegate service providers. So even when they delegate the authority to, move shares across, sell here and there, debit the fund and pay a member and the like, the responsibility on the other hand is not delegated. So they delegate the authority, the consult authority to engage and do ABCD within the fund, but not the responsibility. So that is interesting because even in the agreements by fund managers, you actually find that they are actually absolved from the fact that they made a wrong investment decision. And that is actually very, very, in some fine print within the agreement, to say that, by the way, the responsibility that I invested in this share and it didn't perform well is actually not mine. It is yours as the trustee, which points to the role of the trustees amongst the very, very many things that trustees do. So asking trustees then, you shine the spotlight on them and ask, how many of you have been trained on conflict management and resolution? And here, 76% say yes, and 24% say no, they have not had any training on conflict management or resolution. So then the other question on does the scheme have a conflict resolution policy? Of course, again, responses were varied here. Around 37% say, I don't know. Others, 37% say yes, no, and then 26% say yes, we do have a conflict resolution policy in the scheme. This policy should be a guide for trustees to manage and resolve conflicts for their schemes. And it is a document that's structured around the entire framework of the good governance structures that needs to be placed within the scheme. Then looking at the consequences of conflict, of course, there are those that are positive, and then there are those that are negative. So looking at the positive outcomes is that if we are experiencing some conflict today and we're able to resolve it, then we get a better understanding of how to manage similar incidences going forward. And then again, we are able to explore better solutions. We also benchmark even across regions and the like, and also create an awareness of the importance of active member participation in some of these things, especially where it leads to benefit payments and record keeping and the same. And then also creating a very, very good working relationship between stakeholders. The
negative outcomes are such that people who may not be very formal or very polite in their response to certain things. So there may be insults, you know, like in an AGM, words are thrown as trustees, the way you are eating still money, but when you come back to the ground and you ask, excuse me, how did you eat still money, you know, based on the controls that are there in the life, the risk of having a shilling out of the fund is actually not possible because, like our environment in Kenya here, it's watertight. We'll agree, it's watertight. So, insults, attacks there, maybe some of them not factual. There's also harassment that has been seen in some cases where you even have members that decide to come and camp at the administrator's office, you know. And when that happens, of course, members of the press always thirsty for news. There may be an opportunity for tarnish reputation there, and then at the end of the day, when things are not handled well, then there may be financial loss as part of the negative outcomes. So the discussions were interesting. Most of them, of course, pointing to the fact that RBA should be in the picture, should do so. But if you look at how RBA has laid out the mandates that we have on how to protect the interests of beneficiaries of retirement benefit schemes, it is a process that is step by step. And if you look at each scheme, actually, the first recommendation is that the scheme within it should actually have an internal dispute resolution mechanism. Before it springs all the way to the regulator, then it springs then next all the way to the tribunal, then you find that the first call should actually be, can this thing be resolved within the fund? The tribunal has been mandated, of course, within the Act under Section 47 on how to conduct the same, but the tribunal will not admit any case until you have been satisfied with what RBA has given. And before you get to RBA, there should be demonstrated attempts to be able to solve this thing within the scheme before you take it to the regulator. So with that in mind, I think some of the recommendations that I will repeat from here is that there is need to conduct trainings at all levels and with all stakeholders, and then empower key personnel by creating awareness on the importance of having relevant conflict management skills and knowledge, and then performance reviews carried out frequently to involve conflict management and resolution skills as well. Fourth, in the recommendation was the reporting, which needs to be done frequently, not just for compliance purposes and the like, but also to just ensure that everybody is well appraised on the happenings within the scheme. And part of the gaps also within that space is where there is very little reporting happening from the scheme to the sponsor. More focus is from the scheme to the regulator, and once maybe during the AGM from the scheme to the members. So those ones should be there, and then the reward system should also be very, very clear. Its trustee remuneration, for example, let it be known. Actually, it should actually be even approved by members in an AGM, yes, for this scheme, and such period reward systems where trustees are remunerated, then lessen the conflict opportunity in the scheme. Then timely and effective government interventions, whenever there are areas that need to be addressed, for example, areas that need to be accommodated within policy, then again, timely and effective government intervention will help there. And like waiting until this is triggered by, collective bargaining agreements trying to enforce something and the like, by that time it's gone beyond. And then media should report conflicts in such a manner so as to maintain a good image for the industry. And not pick it and turn it and twist it all the way. And then lastly, I think alternative dispute resolution mechanisms will be good. And here the focus is more on mediation. Which then leads me to what I'd like to highlight around these alternative dispute resolution mechanisms, and here looking at mediation, arbitration, and also expert determination. With mediation, we're looking at that informal procedure in which a neutral intermediary, the mediator, assists the parties in reaching a settlement of their dispute based on the parties' respective interests. So the mediator cannot impose a decision. The settlement agreement has the force of a contract. And then comparing that to arbitration, where the procedure is such that the parties submit their dispute to one or more chosen arbitrators for a binding and final decision. In this case, an award may be based on the parties' respective rights and obligations and enforceable as an award under arbitral law. So the first one on mediation is a contract. The arbitration one will be an award under the arbitral law. And then expert determination will be a procedure in which the parties submit a specific matter, for example, a technical question, to one or more experts who then make a determination on the matter, and this can be binding unless the parties have agreed otherwise. So those three avenues would be good and good to explore for schemes simply because there are certain things that we look at when we are looking at the APR mechanisms. So the time it takes calls for speedy solutions to save costs. Technical and specialized nature of the pension industry is such that most of the time experts advice is usually very, very specific and should actually be positioned from a very neutral perspective. And then the products we have, short products and market cycles also call for time efficient procedures, and then the confidential nature of pension benefits. Because this confidentiality starts from the earnings. So the moment the salaries are kept confident, for example, in an organization, then it spills into the pension scheme, where even the nature of benefits accumulated in the scheme then become also private in nature. Because beneficiaries will be involved here, individuals will be involved here, it also calls for private procedures, which of course is alternative dispute mechanisms would actually provide a platform for. Then collaborative nature of pensions industry, creation and commercialization also calls for mechanisms that preserve relations, because all stakeholders have an engagement that is more long-term in nature compared to other interactions in other sectors. So ADR process framework begins with the parties agreeing, and then from there they move on to a negotiation table, which then now we take the mediation stage, where then we either go to expert determination or be settled at that particular point, or take the other route of arbitration. But the focus at that particular stage is actually look at which procedure will give us the best outcome in all this. So, and it's calls for participation for all stakeholders. If you look at this, we have sponsors in there, we have RPA, we have Kenya Revenue Authority, we have fund managers, custodians, administrators, members, and even actuaries and auditors. All these are parties. Depending on where this conflict is emanating from, we need to bring all parties on board to ensure that the entire industry, especially, aligns to the cost that has been agreed, and also aligns to the fact that we are calling for best practice and benchmarking in whatever we do. Because every case that has been solved today sets a precedence as we move on, and also informs policy in terms of how we want to go. So are there advantages to this proposal on mediation? Yes, it is a faster process. The other thing again is that it is cost effective, it is flexible, it is efficient, it is confidential, it helps preserve confidentiality among the involved parties. It also preserves relationships. And this is also very, very key, as we say, because the relationship between stakeholders at a long-term nature in terms of its engagement. And then it also explores a very wide range of solutions as opposed to other avenues that people may seek to resolve conflicts. It's also expeditious and time saving. We've had court cases, for example, that have taken years and years before they are sorted, and until fully closed, I think Henry will agree with me that it's not only unique to our markets here in Kenya, even in other jurisdictions, cases do take long to be able to be closed. Then is it so clear as crystal that does not have disadvantages? Of course it does. There are confidentiality restrictions, and here the focus is that you'll be in a closed space and you'll feel free that, hey, I think I can admit some things, I think I can make some proposals, I can also make some offers. But in this here, the restriction is such that whatever you have disclosed in this particular space cannot be used afterwards. And one was meant to then use and maybe pursue the case through a different avenue. You cannot use that beyond the mediation process or the subsequent litigation threats or the risks of other arbitration avenues. Then misaligned intentions again is before you come to the table, all parties must have the intention to make concessions and reach a compromise. Then the mediation, if that is not done, the mediation is likely to fail, and it will be a waste of time and resources. And then the other thing again is that it's less expensive, but that does not mean that it does not have costs at all. Costs are there, both in terms of money and also in terms of time that are there. And if the process pays whatever has been spent, of course, will not be brought up for funds, and you can also not recover the time that has been lost. And some of them will also still end up in litigation. And whatever is decided also is not binding in nature. There will be need for continued cooperation between parties. So as long as the parties are cooperating, the process will continue. If any of the parties backtracks, then the entire thing collapses, and it will be having a waste of time and resources. Then the decisions that are there, of course, can also not be imposed upon the parties who have agreed on the same. And the way the nature of those negotiations are coming, we're looking at the Bill of Rights here, looking at so many things. Again, you cannot keep a file and the record that we will be using that in our legal platform where we are able to refer to a case that was done in 1995 and we use it as a basis. In this avenue, we may not have very clear documented cases which we can use to set a precedent for decisions in the future. And then the area of exposure is that it also exposes one, because within that confidential space, then there are chances that you may end up revealing other things that we did not intend to ever admit, like in a court process. Then enforcement will require a court process, but once it is done, then now when you come just to protect and see everything, you may just go in there and then seek enforcement from that particular space. In our environment here in Kenya, this has now been entrenched even within law, within our constitution, to allow alternative dispute resolution mechanisms to actually be explicitly recognized by Kenyan law, and they can now be effectively applied in resolving a wide range of disputes. And that has helped in a good way of deploying the courts, yeah, where we had so many cases piled up and the like. ADR alternatives have actually helped a lot in addressing that. So in retirement funds within our space now, anything that costs money, anything that has an expense is actually very key within that space. Whether it's around the cost of time, whether it's around the cost of personnel, the cost of financial loss based on legal fees, cost of determination, settlement, and resources. Because if it eats from the fund, then on the other hand, it's reducing on the benefits of members. Yeah. So we should actually avoid, if there is an opportunity to do so. So the question we asked, or which I posed to us today, is prevention then therefore an option? And if prevention is an option, then the big question would be, is there something that you and me could have done differently to prevent a conflict in the marketplace, before that conflict happens? And that answer, that question is what actually makes the difference for all of us, and also makes us different as industry stakeholders. So when we trace back to before the conflict, we ask ourselves, is there something that we can be able to embrace early enough to prevent these conflicts from happening? And part of them is to ensure that whatever we do, we first of all, even in setting the scheme, we must set the scheme up in the right way, and then we must manage the scheme in the right way. So set up right, manage right, we will avoid conflicts. And here we are saying services are there from consultants, farms, and the like. We have been setting up, have been drafting and drawing very clear service level agreements. Compliance audits being done frequently are very, very necessary. Scheme documents and policies also drafted and put them in place to guide the operations and decisions at all levels. And then conflict resolution as a stand-alone policy must also be in place amidst all the other good governance policies that are there. Then that is in terms of documentation and setting the framework for operation. Then we must go back also and do training. Build the right capacity among members, build the right capacity among trustees, and also financial literacy among all stakeholders, and then these developments. Everybody was allowed to play within the management of that pension scheme. So, summary of those findings were that, yes, conflicts are there, and their nature as such that they are so varied. They involve all stakeholders. At the end of the day, they have consequences which impact the scheme negatively, and they can be prevented to a large extent. And those are some of the things that we need to explore. But as we look at all that, I think the largest or the worst conflict is that of a member and his man. My closing remarks. The worst conflict is that of a member and his man. Yeah, and this is because if you do all these things and you fail to achieve a lifetime of financial well-being and dignity, then it was all valid. As NWEL, our vision is a lifetime of financial well-being and dignity. So we strive to achieve that, score on that in all interactions with all our stakeholders and everybody who comes across our brand as NWEL Financial Services Limited. So thank you very much. Talk to us. Our services span beyond our country and also within the continent and beyond, because with tech innovations and the like, we are all in one global, small global village. So thank you very much. I welcome any questions that you may have regarding the presentation.
Okay, do we have a question? Let's ask George some questions and then close.
Thank you. My name is Ngidi. I wish to connect George. I think he has the heart of members in him. I think when there is no conflict of interest, when members are taking trustees are able to give to do their duties, and I think it's a good point. I think I need to consider this. Thank you. Keep it up.
Thank you. Thank you very much. Any other comments? What would you like to tell George?
Thank you, George, for that presentation. I will immediately agree with what you have said. And probably it's to point out that the legal cost, and I prefer
lay down a legal cost as opposed to financial loss. It's a cost to the scheme, just like administration cost, just like fund manager cost.
Okay, I agree with you where the legal services 1%, but where they could have been avoided, that's where I categorize them as financial loss, because they are now being onboarded because there is a fund.
Okay, do we have another comment? So, George, thank you very much for making time. Thank you, Henry, for making the trip from Joburg. It's been quite a task to move, to travel. So I thank you both for staying till the last minute. We really appreciate. I don't know whether Henry shared with you his book again. Henry's got a few copies of his book here. If you pension fund trustee guide. So he said he brought about 5 copies. So anybody who might be interested, you can just see Henry. He will be around here. Whether it's at lunch or just within the complex, you can get in touch with him. You can have a look at the book and maybe it can give you some good insights into pension fund trustees with their duties and many other related matters. So with that, I think it will be safe to say we had a good 3 days. I think we learned quite a lot. We've seen even the interest online. We thank our live audience. We thank our virtual audience. It's been quite interesting. We've got a lot of requests for the slides from participants online, and even the ones who are here. So we're going to package that and email them to you and also to the online audience. If you need any further assistance from us, we will be around. I don't know, I think everybody has my WhatsApp number. Maybe I can share it. Should I share it? All right, in case you need any assistance, +27 82 83 49 490. So you can be in touch with me in case of anything. We will be around. Again, I thank my IT team, Alex and Peter from Archer Digital. You've done a great job, and we hope to engage you soon for further, works across Africa. People really appreciate it. I think we only had one reach with technology, but otherwise, people were able to interact with us from all over the world. And that's the beginning. I think COVID has taught us to use technology now to facilitate some of these things. So on behalf of Federated Management Institute, Inside Media, Inside Africa, I will thank you, our sponsors, those who have joined us. Agile actually was also part of our partners. Annual Kenya, we really appreciate your support. We thank all the teams that participated, George and team, the boss, Simon, to make this event a success. As I mentioned again, Aja also supporting us in many other ways. So I thank everyone, and I thank the participants for making the time during this difficult time to travel and come and learn. So thank you very much. Enjoy the rest of the day and enjoy your holidays. Thank you very much.